Is this: you can play this game with trying to say that you are the attorney of fact or whatever, and if you persist in doing so, the only choice I have is to issue a failure to appear warrant for Matthew Aldridge.
So most of what you stated is incorrect, and I'm denying your request to vacate or dismiss. The proper term would be dismiss, but denying that request.
In fact, I'm protecting my Fourth Amendment right.
Your Fourth Amendment right.
Yes.
What right under the Fourth Amendment are you asserting?
I have the right to my own private property, and I do not have to give my name.
That is a very interesting concept. Again, incorrect. Also, Declaration of Independence isn't law. Declaration of Independence was a declaration that we made to King England about what we wanted to see happen in this country. So that's not law. I wouldn't.
Basically, I'm accusing the prosecution of filing a fictitious charging document, and so I don't know where we're going to go with that.
I'm the attorney in fact for Matthew Aldridge.
You're the attorney of fact for Matthew Aldridge.
Yes.
Right. Now you understand Matthew Aldridge is required to be here today because his trial is next week. And if you are Matthew Aldridge, then this is your last day to settle your case by any sort of an agreement. Otherwise, you're going to go to trial next Monday, is it?
The 15th.
All right. You'll be going to trial, and it will be a jury trial. And
Yes,
you're
okay.
going to represent yourself, correct?
Correct.
Raise your right hand. Let's place you under oath. I just want to ask you a few questions on the record. How old are you?
I'll be 40 this August.
And how far did you go in school?
I graduated.
All right. From high school?
Yes.
You've familiarized yourself with the rules of criminal procedure?
Yes, I have been.
All right.
Yes,
So you understand what the rules are regarding a trial. Do you also understand what the rules of evidence are regarding a trial?
Correct.
And you understand that you're going to be held to the same standard, acting as your own lawyer. You have every right to represent yourself, and I'm not saying you don't. I'm just simply saying you will be held to the same standards that any other defendant will be represented by an attorney. Do you understand that? I'm going to ask that you sign this written waiver. Right, you have signed this without prejudice. Is that your name?
Without prejudice?
Yeah, is without prejudice your name?
3-301. Would you like?
Now, understand, we're not going to mess around when we come back next week for this trial.
I'm
not
aware of
gonna
that.
put up with any kind of foolishness where you don't identify yourself. Matthew Aldridge is the defendant. I know you are Matthew Aldridge. You're going to go to trial next week, and you're going to have to be in front of a jury of 12 citizens. We're going to pick a jury. We're going to try this case. And if you are found guilty, then you'll go on to appeals court, and then you'll have a right to an appeal.
Yeah.
But if you come in here and say that you are the attorney of fact, or that you are without prejudice, or whatever the situation is, you understand that I'm not going to put up with that kind of foolishness in front of a jury. You're going to have to represent yourself, but you're going to have to come in here and adhere to the rules. Do you understand that?
Correct.
That he has signed this without prejudice, but I know him to be Matthew Aldridge, and therefore I'm going to hold him responsible for a waiver of his right to counsel. The witness problem, the state has indicated that they may be wanting to dismiss the case against Matthew Aldridge. But Matthew Aldridge has not appeared in this court officially. So what I want you to understand is this: you can play this game with trying to say that you are the attorney of fact or whatever. And if you persist in doing so, the only choice I have is to issue a failure to appear warrant for Matthew Aldridge.
Mm-hmm.
And if you, under oath, tell me today that you are in fact Matthew Aldridge, then we can take steps to try to resolve this matter. So it just boils down to, if you want to stand on your procedures, then what I'm going to do is, and you refuse to identify yourself as Matthew Aldridge, then I have no choice but to issue.
The defendant is trying to separate himself from legal identity to avoid jurisdiction. It feels like control, but legally, it triggers the opposite. The court interprets refusal as non-compliance, not protection. That shift turns a solvable situation into immediate exposure to arrest authority.
For failure to appear against Matthew Aldridge, and I'll have you step back with the officers, and they'll try to identify whether or not you are or are not. You cannot defeat the ends of justice or the justice system by simply trying to say you're not who you say you are. So,
may I speak?
yes, sir. Put that microphone up so we can make sure that, there you go.
By appearing in attorney-in-fact, I am protecting my Fourth Amendment right.
Your Fourth Amendment right.
Yes.
What right under the Fourth Amendment are you asserting?
I have the right to my own private property, and I don't have the right. I do not have to give my name. It's basically the Fifth Amendment too. You're establishing evidence against yourself.
And I've explained to you what's the process is going to be today, correct?
I am aware. I am Matthew Aldridge, as described in the criminal complaints I've set out.
Hold on just a second. Raise your right hand and let the clerk place you under oath.
Okay.
You solemnly swear or give yourself to the
I do.
All right. Now, are you Matthew Aldridge, the defendant in this case?
I am Matthew Aldridge, as described in the criminal complaint that I sent registered mail on Thursday against the witness.
I'm not sure that we have received anything.
Yes, the witness.
We haven't received anything. What exactly were you
It's
saying?
registered mail. I have my tracking number. It's at home. It is registered mail. It went out Thursday from.
So you're using the
Hendersonville.
government entity or a semi-government entity of the post office registered mail to send something to this court?
Well, every time I've stated something on the record in the clerk's office, you've always asked, I haven't seen nothing in the mail. And so I figured that's where you'd be looking for it.
All right. Well, you have identified yourself as Matthew Aldridge, the defendant in this case. And therefore, General Willoughby had indicated that he was going to dismiss this case based upon a witness issue that the complaining witness or the state's main witness was someone who is no longer with the law enforcement here in this area and was not willing to return based on issues that had happened. Is that still the state's position? All right.
Yes, Judge.
All right. Then Matthew Aldridge, now that you have identified yourself correctly as the defendant in this case, then the state is moving to dismiss the charges against you because of a witness problem. Case is dismissed. You are free to go.
Thank you, sir.
All right, I have 3 files here. I have, it's like 2 civil infractions, 1 misdemeanor case. Misdemeanor file is 25F00373OM. People of the City of Burton versus Christopher Allen Renfro, and then the 2 civil infractions, 25F00141OI and 25F00394OI. People of the City of Burton versus Christopher Allen Renfro. And Attorney Odette.
Good afternoon, Your Honor. This is the time set for a pre-trial and possible motion hearing. I received no motions. I don't anticipate there being any at this time. And we're just asking if we continue to the jury trial date, as my associate has indicated that Mr. Renfro is not inclined to accept any sort of offer.
All right, thank you for that. And then Mr. Renfro, can you go ahead and state your name for the record?
My name is Christopher Allen Renfro. Today I am demanding a vacate of these matters for I still do not consent. The jury trial is not a grand jury, so it would be a violation of the provisions of the Constitution of the United States of America. Also, the traffic tickets were not criminal, which this jurisdiction is for criminals, so I'd like those vacated also. No, there was no proof nor burden that the testimony of the cop was proved to be true. And also no evidence. I still have not gotten discovery, which means it doesn't sound like the plaintiff is ready to move forward either. So that's my statement. I demand the court to vacate these matters and restore them whole again.
All right, thank you. So most of what you stated is incorrect, and I'm denying your request to vacate or dismiss. The proper term would be dismiss, but denying that request. One thing that you did mention, though, that I do want to talk about is the discovery issue. And so is there any discovery that Mr. Renfro needs that he does not have?
There's a police report in the criminal matter and then the tickets that he received.
Has that been provided?
I have no way to provide that to Mr. Renfro. He offered it to them previously and he did not take that.
How would you like that to be given to you, sir?
Well, the 24th was the cutoff, so we're past the cutoff. And that means that there's no discovery on either side.
What it means is that the rules in this court are set by me, and if you want discovery, don't remember, we don't interrupt each other. If you want discovery, because you just stated you wanted discovery, so if you want discovery, I'm gonna make sure it happens. So if you want discovery, how do you want to give it to you?
I don't. We're past the cutoff line, and I want to vacate.
He doesn't want it. All right, well, if you don't want discovery, that's fine. In regards to work, also I want to mention, not right, but somewhat maybe along the path towards that somewhere, when you stated the thing about the civil infractions. So you're right, civil infractions are not criminal matters. They are civil infractions for a reason because they don't carry any penalty of going to jail or anything like that. And so you are entitled to a jury trial on the civil infractions. You are entitled to a formal hearing. So my plan would be to have the formal hearings either before or after, depending on how it works out, the jury trial on the misdemeanor matter. Attorney Odette, do you have any objection to that?
I have none, Your Honor, thank you.
All right, and Mr. Renfro, I know you don't want to be here, you don't want to do any of this, you don't consent to anything, but nobody here on a criminal case really consents to it. So is that all right if we do those things at the same time, or would you prefer to come back on different days?
Consent comes from the Declaration of Independence. Their second paragraph down talks about the consent to be governed, and also William Lynch letters talks about when slavery ended, commerce was created. What differentiated the two was consent. So maybe we need to go back to our books.
That is a very interesting concept. It's, again, incorrect. Also, Declaration of Independence isn't law. Declaration of Independence was a declaration that we made to the King of England about what we wanted to see happen in this country. So that's not law. I wouldn't quote that anymore. I would quote
Reasons why
other
they went
things.
to war with England.
One more
was
time,
Sam in America.
don't interrupt each other. We're gonna keep doing this, and I'm gonna keep reminding you of that, because if you try to do it while we're having a jury trial, I'm gonna shut it down way faster, because we're not gonna do it in front of a jury. All right, so again, remember, we don't interrupt each other. So let's go back to the question, which was, would you like to do the jury trial and the formals on the civil infractions on the same day, or would you like to do them on different days? That's the only answer I need right now.
Proceed how you feel, because you already have, so.
Okay, I agree with that. So we will set them for the same day. I think that will be more convenient for everyone involved. And
Thank you.
we do try to be convenient for people around here. Okay, and so let's set this then for.
I believe it's already set. I believe there's already notice for the, I don't believe it was on 8 set, I mean.
But it was not set for today.
Okay. If we set this for August 7th, Mr. Renfro, is that an acceptable? I know no date is acceptable to you, but are you free on August 7th?
On summons, I'll be here.
Okay. All right, you'll get a notice. We won't send you a summons, but we will send you a notice for you.
Only summons a little bit.
Well, if you don't show up, I'm going to issue a bench warrant for your arrest, so be fair warned. August 7th, jury trial, 2025, August 7th at 8:30 a.m. That will also be the same date for the formal hearings on the civil infractions, and like I said, I'm not real sure which ones we'll do first or last, but I'm thinking we'll probably do the jury trial first so we can get the jury in and out of here, and then we'll move on to the civil infractions. That way, if we have to come back the next day on the civil infractions, we don't have to bring the jury back. Last thing before we leave, Attorney Odette, you mentioned that, actually, there's two more things I want to talk about before we leave. One, you mentioned that today was set for pre-trial and motion, and I do have as well have it that there's no stuff for motions, but I don't have any written motions filed. Did either of you file any written motions?
I did not, Your Honor.
Did you? Mr. Renfro?
No, I do not.
No? Okay. All right, so I don't know why that was set for that. I know you made an oral motion today, but. All right. Well, then that's not an issue. I will also note that right now the jury trial actually has a date for Friday, September 5th at 9 o'clock.
Yes, that was the date that we subpoenaed.
This is the date of Mr. Becker's trial.
Okay,
When we originally scheduled it to coincide,
gotcha.
and it just kept moving forward.
Gotcha. All right, so do we want to do August 7th or September 5th? It's like either day is gonna be fine.
Well, I think of course discretion.
I'd say August 7th is good a date as any, so we're gonna, we had it originally set for, I think it was, July 25th. We had to move it because there was kind of emergency or something. I don't remember what happened on that date, but it was something weird. So then we moved it, but we'll move it back to August 7th. That way we can get Mr. Renfro in a little bit sooner rather than later. I think those are all the things that I wanted to cover, except one more time, Mr. Renfro, I know we've already talked about this, but it is your intention to represent yourself in this matter, is that true?
It is my intention to present this cause.
Okay. You do not want me to ask the public defender's office to appoint you an attorney, is that right? You don't want that, right? And you do not want to retain an attorney, is that right?
Correct. I'm competent and I will see these matters through myself.
All right, you understand, I know we've talked about this before, but you understand that Attorney Odette and people that work in our office that are lawyers have law degrees, they've been through law school, they've been doing this for many years, and according to the people in the legal system, you are going to place yourself at a significant advantage by representing yourself. Do you understand that?
Advantage? Yes.
A disadvantage. I'm sorry, I didn't say advantage, I meant disadvantage.
I see it another way, but that's.
And that's fine, that's why people represent themselves, they think that they can do it, and you seem pretty confident to me. As long as we all respect each other and respect this room, everything will be fine and you can represent yourself. I don't have a problem with that. But if we start crossing those lines, that's when we're gonna have a problem, okay? All right, I think that's it for today.
Thank you.
Thank you.
May I have a second for Mr. Renfro?
Yes.
AR 133, State of Kansas versus Gregory Brian Kelly. The state appears by and through Greenwood County Attorney Jill Gillette. The defendant, Gregory Kelly, appears in person and pro se. Mr. Kelly, are you still wanting a jury trial, or do you want an opportunity to try to negotiate a disposition with the county attorney?
Thank you, Your Honor. Good morning.
Good morning.
I am willing to talk to the prosecutor, but I don't think we're going to come to a resolve.
Is that you have your mind made up, or you're open to thoughts if she discusses it with you?
That is correct, that I'm open to anything she might say.
Very well. Ms. Gillette, he has signed a waiver and continued to represent himself throughout. Are you available and willing to talk to him this morning about possible resolution?
If he wants to talk, I made an offer before, which he continues to not want, so.
Yeah.
All right. Well, I'm going to put the two of you in a breakout room and have you hopefully keep open minds. And Savannah, if you would put Ms. Gillette and Mr. Kelly in a breakout room, please. In the meantime, Ms. Gillette, Mr. Kelly, any success? on
No,
negotiation?
Judge.
No?
No, we weren't able to come to agreement.
Okay. Ms. Gillette, let's go on the record in Kelly again. We are on the record in 2022 CR 133, State of Kansas versus Gregory Brian Kelly. Please announce appearances.
I'm here, Judge.
All right, Gregory Kelly appearing in person and pro se. Ms. Jill Gillette, County Attorney, are you here? Ms. Gillette is on the record with us in 2022 CR 133, State of Kansas versus Gregory Brian Kelly. Mr. Kelly's case is now the prime for Wednesday, but the dilemma now is that Judge Hart has a Greenwood County case announced for prime also. So I suppose that puts us as an alternate maybe to whatever he has. Ms. Gillette, what do you have in front of Judge Hart this week?
Currently, it is scheduled for an aggravated domestic battery case with multiple other charges that have been, that are between the two cases. Two cases consolidated for trial. The other one is violation of a PFO. That is also scheduled to possibly start Wednesday. This case is a backup to that case. So if you want us to appear in case the other case works out, I was going to call Nika Cummings and confirm today on everything with that. So.
All right. Well, Mr. Kelly, it sounds like there's a possibility your jury trial may go Wednesday. So you'll need to be prepared and at the Greenwood County Courthouse between 8:30 and no later than 8:45 Wednesday. Judge Hart and Ms. Gillette will be in the jury trial in front of you, but if for some reason that would resolve itself in plea, as they often do, or some other disposition, the jury will be ready and waiting. So are you quite certain that you want to represent yourself in front of a jury on Wednesday?
Yeah, I am, Judge. Also, if I might add, there has been some new evidence in this case that has came about, and I am in the process of checking into that, and basically I'm accusing the prosecution of filing a fictitious charging document. And so I don't know where we're going to go with that, but I have hired a forensic handwriting specialist. At the moment, he's supposed to be acquiring handwriting samples, and I'm not sure how this case can go forward until we get this matter figured out.
Okay, first of all, with all due respect, sir, what are you talking about?
Okay. The Secretary of State has confirmed that the notary's signature that is on the charging document is not on their file. In other words, it is a forgery. Somebody forged the notary's signature declaring the prosecutor's oath.
You could say that again. The Secretary of State, the state of Kansas, says that whoever signed that document was not a legal notary in the state of Kansas.
Correct.
So you're making the argument in your criminal case that Ms. Gillette did not file a legal petition, a legal verified petition or notarized petition.
I'm saying fraudulent.
Well,
I at this point I am challenging the prosecutor's jurisdiction. I feel she has no standing due to the fact, knowingly or unknowingly, she filed a federal document that was falsified.
first of all, she did not file a federal document. We're not in federal court. We are in Greenwood County District Court. Second of all, she is the legally elected authorized prosecutor for Greenwood County. And and she did sign the complaint and information filed against you.
I don't believe she did. I think
Well,
that,
let me call it up. I've seen her. I'm not designated with credentials as an expert handwriting analyst, but I will tell you, I've seen this woman's signature so many times in the last several years. Let me pull up that document and look at it.
Yeah. Judge, if I may,
Let me look at your signature.
this
Yeah,
is actual original with the original ink on it. That's Miss Arlene's signature in blue ink. This is my signature in black ink. I can attest that is my signature. I definitely know that's Arlene's signature, and Arlene signed it in my offices. So I know that that's her actual signature and it's not forged. And then in addition to that, this is the State of Kansas Secretary of State's notary search I've completed today. Arlene C. Edwards is a bona fide notary. There's her expiration date.
she is registered, yes.
August 30th of 24, and she was commissioned August 30th of 2020. There's her commission number. She is a bona fide notary. It's our actual signatures.
Judge, she is in fact registered with the Secretary of State in Kansas. So therefore, if she is registered, her signature is on file. And I have a letter saying from the Secretary of State that says that the signature presented on that document is not on their file, not in their file. So therefore, it only stands to reason that it is someone else's signature.
okay. I have seen Arlene Edwards' signatures.
You can have her log in. She'll testify that's her signature. I mean,
No, I know Miss Edwards and Miss Gillette's signatures. Again, with the untrained eye, but having seen them every day on multiple documents for several years. Miss Edwards, in fact, even more than Miss Gillette's, because she was authorizing signatures for Mr. Lee, the predecessor to Miss Gillette. Who did you talk to in the office? Is this someone you can have come down as a witness?
I sent in a form that you're required for authentication and apostles, and that they responded to that form that I sent in.
Okay, well, I don't know that you've actually formally filed a motion, but nothing you've said convinces me that legal grounds would disqualify this case from going further to trial or disqualify Ms. Gillette from prosecuting it. Now, if you want to bring down a witness and present them, you can do so, but what bearing would that have? The issues for the jury, Mr. Kelly, will be count one. Did you on or about the 10th day of August, 2022 in Greenwood County, Kansas, unlawfully and intentionally possess an hallucinogenic drug, to wit THC and or marijuana, after having a prior conviction for the same in Labette? Is that Labette County or Labette, Colorado? That's Labette County?
Yes, Kansas.
Okay. And then in count two, and that the jury's going to have to decide if the state can present the elements of that. And then they're going to have to decide the elements of unlawful possession of drug paraphernalia in count two. The state's alleging that on or about the 10th day of August, 2022 in Greenwood County, Kansas, you did unlawfully and intentionally possess drug paraphernalia, specifically marijuana roaches, which I understand are marijuana tobacco and rolling papers. So it'd be the rolling papers for the purpose of either storing, containing, concealing, ingesting, inhaling, or otherwise introducing a controlled substance into the human body. So those in counts 1 and 2. Then you've got count 3, whether you were operating with insurance on your vehicle and whether you had a valid tag. Those are the charges. Those are the things that you would have to be, if you wanted to present a defense, you'd have to be answering to. But I don't know whether
I feel as though if in fact the charging document was falsified, then therefore she would have no standing in this matter.
Okay.
Would it not at the very least be a conflict of interest, Judge?
I am finding that there is no conflict of interest. I'm finding that it is a valid document and that we will proceed. So on the evidentiary merit. Now you can reserve your right to appeal my decisions. You're welcome to do that. And I will note that you have made those objections to proceeding. But
if I in fact can prove that it is a falsified document, would that not be, would she lose her standing at that point? I mean, I understand you're saying you don't believe it is falsified, but I'm asking if it was.
We're going to proceed on the charges. If you prevail, that's that. If Ms. Gillette prevails on the charges, you can file whatever grounds you feel are appropriate for appeal and take those up with the Kansas Court of Appeals, sir.
Okay.
All right. So that being said, you'll be ready for trial on the merits tomorrow if we proceed?
Are you asking me if I am?
I'm asking if you're prepared, yes.
I don't feel that I am, because I feel that I need to further investigate my alleged accusation against the prosecutor's office.
Okay, your position is noted and I've overruled it and we're going to proceed then. So be here Wednesday at no later than 8:45, ready for jury trial.
All right. Thank you, Judge.
Thank you. You may go, sir.
Thank you.
You're welcome. Now, Missy, I think if we go off YouTube for this last hearing, I think folks would.
Across these hearings, the pattern is consistent. Each defendant substitutes legal reality with personal interpretation, and each time, the system responds the same way. The first defendant delays a dismissal by refusing to identify himself. That single decision almost converts a favorable outcome into a warrant. The court isn't debating philosophy, it's enforcing procedure. Identity, in this context, isn't optional. It's the entry point to resolution. The second defendant rejects discovery, then uses the lack of discovery as a defense. That's not strategy, it's self-sabotage. Courts provide tools, but refusing them removes any claim of unfairness later. Once that window closes, the responsibility shifts entirely onto the defendant. The third defendant focuses on attacking the legitimacy of documents instead of preparing for the actual charges. That creates a critical misalignment. The court is focused on elements of the offense. He's focused on jurisdictional theories that don't stop the trial from moving forward. This is where sovereign citizen arguments consistently fail, not because they lack confidence, but because they operate outside the system they're trying to defeat. And the system doesn't pause to debate those beliefs. It moves forward, with or without them. Every time a defendant chooses principle over procedure, the court responds with structure over argument. And in that gap, consequences quietly build.